Hello, and welcome to all of the participants who have registered to join us today for this expert roundtable on the policy on the crime against humanity of gender persecution released last December by the Office of the Prosecutor of the International Criminal Court. This event is the fourth in our series devoted to the Office of the Prosecutor's recent policy on prosecuting the crime of gender persecution. In this conversation, we will discuss the intent to discriminate element in the gender persecution provision of the International Criminal Court's Rome Statute. My name is Milena Stereo, and I'm the Charles R. Emmerich Jr. Calfee, Halter, and Griswold Professor of Law at Cleveland State University's College of Law, and also the Managing Director at the Public International Law and Policy Group. I'm honored to be guiding the conversation with my colleagues. As with all forms of persecution, accountability for gender persecution requires recognition and understanding of the discrimination that underlies the crime. This roundtable will look at this discriminatory intent element within the gender persecution prohibition in the Rome Statute and discuss how a holistic understanding of the reasons why perpetrators commit persecutory acts can work towards elimination of discrimination and break cycles of violence. Our speakers will also unpack the intent versus motive to commit crimes distinction and how gender persecution may, and frequently does, intersect with and constitutes multiple forms of persecution. This roundtable today is co-sponsored by the Women in International Law Interest Group at the American Society of International Law and by the law firm of Orrick, Harrington, and Sutcliffe. The Women in International Law Interest Group at the American Society of International Law was created to promote and enhance the role of women in the field of international law. In addition, the Women in International Law Interest Group works to promote awareness of gender in all areas of international law. The Women in International Law Interest Group sponsors panels, as well as a luncheon at the American Society of International Law annual meeting, and recommends speakers and experts on a variety of international law topics. Orrick, Harrington, and Sutcliffe is a global law firm and a long-standing PILPG pro bono partner. Orrick has supported PILPG's work with matters regarding the Rohingya in Myanmar, Ukraine, Libya, Sudan, Yemen, as well as PILPG's engagement with the International Criminal Court, including regarding specific questions and issues related to the gender persecution policy. We're honored to be joined today by Professor Lisa Davis, Professor Kim Tui-Seelinger, Madeline Rees, and Pubudu Sachidanandan. The roundtable will be 60 minutes long, and we ask that you please submit any questions you have for our speakers using the Q&A function, and we will do our best to answer your questions either throughout the event or towards the end of the discussion. Now, please allow me just a few moments to introduce our panelists. We're honored to welcome back Professor Lisa Davis, Special Advisor on Gender Persecution to the International Criminal Court's prosecutor and an Associate Professor of Law and Co-Director of the Human Rights and Gender Justice Clinic at CUNY Law School in New York City. Professor Davis has written and reported extensively on international human rights and gender issues, including women's rights and LGBTQI+ rights, with the focus on peace building and security issues in conflict and disaster settings. I'm also thrilled to introduce Professor Kim Tui-Seelinger, an expert on sexual violence in the context of armed conflict and forced displacement. Kim is a research associate professor of social work, public health, and social policy, and visiting professor of law at Washington University in St. Louis, where she also directs the Center for Human Rights, Gender, and Migration. She's on academic leave at the moment, working at the International Criminal Court, where she has since 2021 served the prosecutor as his special advisor for sexual violence in conflict, and she's joining us today from The Hague. Welcome also to Madeline Rees, Secretary General of the Women's International League for Peace and Freedom. In 1998, Madeline was appointed as head of the Office of the High Commissioner for Human Rights and their gender expert in Bosnia and Herzegovina. From September 2006 to April of 2010, Madeline served as the head of the Women's Rights and Gender Unit for the Office of the High Commissioner for Human Rights. And also welcome to Pubudu Sachidanandan, a trial lawyer at the Office of the Prosecutor of the International Criminal Court. In the past 2 decades, He has served in a number of institutions on teams investigating and prosecuting crimes that occurred in Uganda, Rwanda, Myanmar, Sudan, the Central African Republic, and the Democratic Republic of the Congo. Welcome, everyone, and thank you for agreeing to participate in today's panel. As usual for these events, let me start with Lisa. Lisa, let's discuss the mental elements for gender persecution. Can a perpetrator commit gender persecution unintentionally? In the intro, I mentioned that discrimination underlies the crime of persecution, but can you explain to our audience what exactly this means?
Sure. Oh, I'd be happy to. So in order to find a finding of gender persecution, you have to establish specific intent. So it can't happen unintentionally. Although I think sometimes there's a bit of a conflation between intent and motive in terms of how we unpack what intent means, when gender-based violence can be so normalized within us. So when we're talking about the difference between intent and motive, we're really looking at intent as the act of intending to do something, meaning that it's something you intend to do, something you will do. Motive is the reason why you do something. So, for example, the example I always use with my students is I say, well, look, if the man said he stole the money because he wanted to buy a car, then the intent was to steal the money. The motive is the thing he wanted to do. It's because he wanted to buy a car. Now, this becomes a little bit tricky when we're starting to talk about gender persecution crimes, because in those crimes, often the persecution looks like the motive to the crime. For example, if a perpetrator said he killed the victim because he thought the victim was Yazidi, here we see the intent was to commit murder, and the motive would be ethnic persecution, right? The motive would be the intent to discriminate against Yazidi persons. So then it becomes this issue where motive can be conflated with intent. That's why with gender persecution crimes, you need to prove two intents, because you actually have two crimes. You have the underlying act or crime that you're attaching the persecution to, the rape, the torture, the murder, and then you also have the persecution. And there's an intent that goes to persecution as well. So you have to prove two intents. You have to prove the general intent to commit the crime, and then you also have to prove the intent to persecute. And we prove the intent to persecute by proving that the persecutor or the perpetrator intended an unequal outcome against that victim. And then the why he may want that unequal outcome, that becomes, that is actually motive. So I hope that answers your question.
It does. And let me just follow up on that just a little bit. So would you say that both motive and intent, and specifically the intent to discriminate, are always present at the same time, or not necessarily?
Well, that's an interesting question, too. I mean, certainly perpetrators can have lots of motives or reasons why they commit crimes or even persecute, but there always has to be intent. So you're always looking for the perpetrator's intent to commit unequal treatment. I think where this really becomes an issue is when we're looking at crimes like rape or other forms of sexual violence, because in these crimes, oftentimes, you hear these reasons given for why a perpetrator might commit rape, such as opportunistic rape or sexual gratification. So putting aside the political beliefs we might have around these terms, if you just take them at face value, would actually be motives. It's not there to establish the intent. And intent is about the intent to treat a group unequally. And we know that rape is almost always a form of discrimination. It's almost always committed with the intent to discriminate, just because of the nature of the crime. And usually how this breaks out in a conflict situation is there'll be these narratives that perpetrators may put on women. There's the good girl, and then there's the bad girl. And the good girl is the girl who isn't raped. She's the girl who goes to church. She's your best friend's wife. She's that girl who is upstanding in society and following the gender roles that have been assigned to her. The bad girl is the girl who doesn't follow those roles. The bad girl may be a bad girl simply because she belongs to an ethnic minority. That girl is usually looked at as a girl who is rapeable, or a woman who is rapeable. And so this distinction shows us unequal treatment. There's unequal treatment to women who are perceived to be eligible for the crimes that perpetrators impose upon them. So when we look at it this way, when we see this dichotomy that's often happening in conflict, we realize that it's not about opportunity and it's not about sexual gratification. And if those things exist, those are motives, but they're not intent. The intent to treat unequally still has to be proved. It's almost always still there. It just gets muddled with these other forms of motives.
Thank you, Lisa. Now let me go to Kim next. Kim, would you like to add anything related to this topic? Maybe something from your work regarding refugee law?
Yeah, thanks, man. Just a quick 2 cents just to build on what Lisa just gave us, because listening to her always makes me think of parallels in refugee law, actually. And as you all probably know, even though it's a different body of law, obviously, there are some things that are interesting to think about, because persecution and the question of persecution is central to the 1951 Refugee Convention, of course. And so listening to how gender persecution plays out in international criminal law always reminds me of developments on gender-based persecution in refugee law. And one thing that I was thinking about listening to Lisa right now is how, one question that comes up in some cases, not many, but some gender persecution cases in the US, for example, demonstrate how you can have gender-based persecution without malicious intent, actually, or malicious motive. I'm thinking of cases we've had in a number of different courts in our federal system where, families from communities that practice female genital mutilation or female genital cutting, for example, apply for asylum on behalf of their child, the daughter they're trying to protect from this rite of passage in their home countries. And certainly, there's no question that the elders and the other family members who are trying to engage or practice this tradition, there's not malicious intent necessarily, or malicious or motive either way, as Lisa broke out for us. Truly, in most cases that we see, there's certainly evidence of the country backgrounds information that families are trying to preserve a girl's marriageability and ensure her place in a society. But nonetheless, the act itself is understood, to be a form of discrimination that has persecutory elements to it. And so in those cases, we see that what matters is that the persecutor is discriminating on account of gender when intentionally committing the act that is deemed to be persecutory. It doesn't matter that they didn't harbor malice in that, actually. So I just wanted to add that, just listening to how Lisa separated out intent and motive for us, is just an interesting echo in refugee law. Thanks.
Thank you. Now, Pubu, let me go to you next. And I'm going to ask you to build upon the same themes raised by Lisa. From wearing your prosecutorial hat, what do you need to show? What kind of evidence do you need to show in order to show specific intent for direct perpetrators? How hard or how easy is it from the prosecutorial side?
Right. And of course, I'll begin by saying that is a very case-specific, there's a case-specific answer to that question, depending on the political context, the social context, etc. But having said that, if you look at cases relating to persecution in the past, you have, I guess, what you would call gold standard evidence in the context of the acts or statements of the perpetrators. If you have, for example, the euphemistic statements or the use of hate speech, discriminatory speech itself, that is often a useful indicator. There can be, the ideology of the the attacking group or the perpetrator group as evidenced in policy documents, in legislation, all kinds of communications. So that's useful, but that's not necessarily the only way you can prove persecution based on gender or persecution based on gender and other intersecting types of discrimination. You can have a certain pattern of targeting. If certain individuals who identify as having a certain gender are separated during a course of conduct launched against a civilian population, then that in itself is an indicator of discriminatory intent. So I would say, yes, you have explicit statements being used by perpetrators. We often cite that sort of evidence, but you also have other types of targeting from which you can infer discriminatory intent. And both of those types of evidence, I think, are considered equally valid by courts.
Thank you. Now we actually have an interesting question in the Q&A that asks about the ICC, and the question is as follows: has the ICC already prosecuted cases where gender persecution has been charged as a crime, and if so, has the OTP been able to bring such cases successfully? So, Pubudu, maybe you want to comment on that?
Sure. I mean, I'll begin by saying I'm speaking, of course, in my personal capacity, so please don't consider this a commentary on any case that I'm currently prosecuting. But yes, if for those who are interested, the Al Hassan case related to the Mali situation has charges related to gender-based persecution, and these are also interestingly intersectional charges which relate to other grounds of persecution as well. And I believe in that case, the parties have rested, but there is no judgment. We have the Abdul Rahman case, which relates to Sudan. And there again, the prosecution has alleged a number of different types of persecution, again, intersecting with each other. And one of those bases is persecution based on gender. And I believe the Said case also has has a charge relating to persecution based on gender. None of these cases have come to judgment yet, but I think those are very interesting cases to follow. And of course, if you read cases like the Ongwen case, in which there is a judgment, you have interesting discussions of persecution without explicit mention of gender-based persecution.
Thank you. And I think we'll have time towards the end of the roundtable to talk a little bit more about intersectionality, but thank you for mentioning that. Now, stepping back a little bit, my next question then is for Madeline. Madeline, how does gender persecution contribute to our understanding of human rights?
Oh, thank you. And I think I'm going to build on everything that's been said so far, I think, because fascinating that the initial discussion starts off with what my friends would call typical lawyers splitting hairs over language which we're seeking to use to describe what's actually happening to someone. And then you pull back and you actually see, well, actually, it applies absolutely to those lived experiences. And that, I think, is where human rights law really comes in to try and set a context within which gender persecution can be better explained. So I think, just coming from that perspective, if you think of all the various laws we've got from human rights perspective up to and including the UN Security Council resolutions on women, peace and security, we've done really well in having legal frameworks which ostensibly will end discrimination. But the fact that we're sitting here talking about gender persecution means we haven't achieved it. Now, why haven't we achieved it? And I think the answer to that is that whilst we've been working hard trying to establish law to end discriminations in its multiple facets, the nourishment hasn't been there. We haven't looked at the structural nature of discrimination. We haven't looked at economic systems of exploitation and how they impact. We haven't looked at militarization and how that impacts. We haven't looked at that close connection between social economic rights and civil and political rights. And as a consequence of that, we do have this incredible ingrained gender discrimination, which is being unpacked over the ways of which gender persecution, particularly the work that Lisa's done, in trying to understand better how that works in practice. So if you look at it, where there is gender equality, literally, you're much less likely to have conflict. Where there is equality, it's a better indicator of whether or not there will be peacefulness in a society than anything like democracy, religion, GDP. And where there is massive inequalities, it's a predictor of conflict. So, as I say, actually, I think it's 14 of the 17 at the bottom of the index on gender equalities have experienced conflict in the last 2 decades, which is quite a statistic. So all of which is showing us that where you have gender inequality, because of a political economy, as outlined by those who have worked like Jackie True on the political economy of violence against women, where you have that, you actually are creating fault lines which enable an inequality in who has power and how it's used. Consequences of that are basically the setting of the fault lines that lead to conflict, but also then what happens during the conflict. And the one elides into the other. And the importance of having gender persecution working and lying as being based in human rights is it shows that this is not a coincidence. It is no coincidence that we have this incredible discriminatory frameworks structurally within states, and human rights law can only go so far in trying to address those. Now we have the docking station of gender persecution, which shows the intentionality of that structural discrimination. And that's why it's so important, because now we move from the human rights context into one where there is criminal outcomes for those who perpetrate it. And I think we can talk a lot more about how we can use that in order to improve our understandings of how discriminatory law works within the human rights context.
Thank you, Madeline. Now, my next question is for Kim. So turning to this notion of a more holistic understanding of reasons for committing persecutory acts that I referred to in the introduction, the gender persecution policy itself refers to this holistic understanding in a very concrete manner. So Kim, can you tell us a little bit more about what the policy means when it speaks about this holistic understanding, and why is that so important?
Sure, I'm happy to comment, and I know if Lisa has any thoughts, she's welcome to chime in. But if we step back and just think about what we mean when we even say holistic, because I think sometimes we use the word and we don't necessarily we're not necessarily on the same page as to what it might mean. And it means not only seeing or tending to the whole of the thing, but truly it means understanding that the whole is greater than the sum of its parts, right? So many of us who work with survivors think most immediately of the term when we're thinking about holistic care, where we have co-located services or wraparound services for survivors who may need legal or medical or psychosocial support. It's something like that, where presumably if you deliver all of these different components, the added benefit, there's a benefit that is greater than providing any single strand of support, right? So this is a common understanding or use of the term holistic. I think in terms of international criminal law, to develop a holistic approach to investigation and analysis and prosecution can mean not only understanding the context of and the connection between the acts of violence that we're looking at, so we can characterize them fully and faithfully when developing charges, for example, but also what in that context do they mean or amount to altogether. And the concept of gender persecution is such an incredible example of how we need to do this. And it's important, gender persecution is important in taking this holistic approach because it helps us look beyond any specific act or conduct, which itself could be characterized as any number of crimes under the Rome Statute, for example, or whatever statute we're talking about, to identify where gender discrimination may be operating in the background as a driver for that conduct. And I think when we look and we do that really intersectional gender competent analysis, we can see that those forces of gender discrimination in the background pushing that one piece of conduct are actually influencing and pushing a number of other acts also that may on the surface look quite different or disconnected. So the gender persecution inquiry helps us really surface what's happening in the background of a number of acts that may on the face of it look quite disparate or unconnected or not gendered, actually, right? So I think if we can tap into that, then we start to see a situation more fully, and perhaps the acts that we're looking at take on more clarity, more intensity. And this is a holistic view of what's happening. The policy itself raises sort of this term holistic, or this concept of a holistic approach in the gender persecution policy in a number of ways. I looked through, I did my Control F, and I read through a little bit to see how it was using the term. And this, Lisa, correct me if I'm wrong here, but it seems that it's arising in three general ways. One is in terms of taking a holistic or developing a holistic understanding of perpetrator intent, which we've talked about a bit already, so I won't go into too much detail, but this is really where the intersectional analysis helps us see all of the different things that someone might be targeting, or all the different systems that might be making someone vulnerable or targeted in the first place, right? And this, I'll give you an example that was in the policy, of course, is you can have, if you take a holistic approach, then you'll understand why the act of rape, which might be visited upon men and women in a given context, may nonetheless have different meanings and different impacts, right? The same act, well, not mechanically the same, perhaps, not identical, but the same crime. If you take a holistic understanding and understand the social norms, the gender norms in that particular context, one might realize that actually the rape perpetrated as a form of discrimination against women is because they're viewed as chattel or as war booty, for example. And then the same act visited upon men for different reasons maybe uses a strategy to feminize them. And so this is the holistic approach to understanding perpetrator intent, looking full circle at all of the gender norms that might be bearing or weighing upon their acts. The other way that it's mentioned, second way, is the intersecting persecutory grounds. And this was interesting in the policy. It reminds us that gender persecution may manifest in a number of different ways, including destruction of cultural heritage, right? If we understand that certain sites and locations, for example, may have specific meaning or be gathering sites for women or LGBTIQ individuals, the destruction of that location itself may be a form of gender persecution if that is the gender disparate impact that occurs. And this is part, again, of taking that holistic approach. And then just the third way that I think it's used in the policy is in terms of completing the historical record. And again, this is resonant with refugee law a little bit, understanding that even cumulative harm, lower frequency acts of violence that may not, as individual incidents, seem to rise to the level of persecution, may together, combined over time, constitute persecution and a form of gender persecution. So this allows us to surface those smaller acts in the historical record to show actually this low frequency violence that we're seeing in the background and not counting as individual incidents together do constitute persecution. So I think that's another way the term holistic approach is, or those approaches being expressed in the policy, which is incredibly interesting, I think.
Thank you. And I do have to ask Lisa if she has anything to add on this.
I mean, I think Kim said it brilliantly. So the only thing I would piggyback off of what Kim was saying, and it answers a question in the chat around the importance of charging gender persecution as a separate charge, is that it tells the holistic story, right? It helps to tell the holistic story of what happens in conflict. That things like misogyny and homophobia, like what Madeline was talking about, they really underpin conflict. They're exacerbated in conflict. They fuel violence. And if we don't capture that story, if we don't capture why crimes happen, that, why was a woman tortured because of discrimination, or why was a man killed because he was perceived as gay, if we don't capture that why, we're only telling half the story of what happens in conflict. And that's why it's so important to add the charge of gender persecution.
Thank you, Lisa. And you were reading my mind, because I was actually about to ask you that question from our Q&A. So thank you to the audience member for asking that question. My next question then is for Madeline. Madeline, can a better understanding of gender persecution, can that actually help towards the prevention of this crime?
Can I cheat a little bit and comment on what's just been said as well? Because what I think gender persecution has done, we do a lot of work with women from Afghanistan, or people from Afghanistan, and increasingly in Iran, because the language of gender persecution is now very current in the Human Rights Council. And it has meant so much, because it has accurately, really bring together the entirety of the experiences. It's the picture, if you like, of what they have seen happen around them. Nothing else captured it the way that persecution does. And I think you'll probably find that most Afghan women and Iranian women are well ahead of the game in terms of being able to better explain what it is and how it works and the impact it has on them. So I think that in itself is proof, if you like, of the accuracy of the way in which it has been put forward by Lisa and Kim in particular. Can it help? Yes, it can. Because I think most of what we do when we end up in criminal law, we really don't want to be there. We want to be in the prevention game ahead of it to stop it happening. And what I was saying before about if we know that is these structural discriminations which cause the fault lines which lead to conflict, then we need to stop doing what we're doing. We can actually start interrogating the way in which policies towards education, towards healthcare, in particular social reproductive rights, sexual and reproductive rights, how does that have a disparate impact? How does the way in which we enable and facilitate participation in governance structures, the way in which we enable and facilitate participation in economic structures, and how do we change them? Because the economic structures we have now cannot enable inequalities to be dissipated. So how do we do that? And we scrutinize those upfront, through the various mechanisms we've got, looking at how, if you report to CEDAW, if you report to the Universal Periodic Review, where is our gender analysis in all of those taking us? How do we actually see where those early warning indicators are taking place? And we can look at what's happening in the States. You start burning books, you start removing books from libraries which actually reference and include a greater understanding of what gender is, you're creating fault lines. And we do that at our peril. So we must, I think, in all cases, start really paying attention, using the tools that we've got now, which gender persecution have given us in terms of seeing that holistic approach, that totality of understanding, and then better analyze, better interrogate where things are going wrong, so that we can then seek to adjust with the support of other states, because economic social rights governance says we should have that in order to try to find redress. And so I think that is the direction in which we should be putting our focus, so we don't end up having to ask the ICC to take the cases on persecution.
Thank you, Madeline. My next question is for Pubudu. You already mentioned intersectionality. So how does gender persecution typically interact with other forms of persecution from your prosecutorial investigative experience?
Right. So, in fact, I think there's almost an inevitable interaction. I mean, if you talk to an anthropologist or a sociologist who especially those who work with the law, they will often say that the criminal law is a blunt instrument. It often lags behind other types of analysis. So, but if you look at how people are victimized, if you look at how people are targeted, it's often a complex interaction of different aspects of their identity. You may have, for example, women targeted, partly because of their gender, but also partly because of their ethnic group, and also targeted because of their gender, because of their ethnic group, but also because that ethnic identity says something to the perpetrator about their political affiliation. They may also be targeted because of their skin color, which again says something about their ethnicity. So you can see how in real life, targeting often involves a multiplicity of factors that constitute the identity of an individual. And historically, we have been very blunt about this, but that's the value of bringing in gender-based persecution, because then we go back to taking a holistic approach. And you will see this in cases before the ICC, where, for example, you will see the targeting of women from a particular ethnic group who may have a certain color of skin. You may even see the targeting of men of a particular age group from a particular ethnic group, which indicates affiliation, at least in the eyes of the perpetrator, with a particular political group. So it's in that, and you'll see this, for example, in almost every case where gender-based persecution is charged at the ICC. Yeah, I'll stop there.
Thank you. Now we have received some excellent questions from our audience members. So let me turn to some of those now. One of our audience members mentions that the position of the European Parliament is that the prohibition of discrimination must not undermine respect for other fundamental rights and freedoms, including freedom of religion, etc. In many countries, discrimination and persecution based on gender are religiously motivated. How to reconcile the prohibition of discrimination and persecution based on gender with the freedom of religion? And I would add to this question also that at times, discrimination is justified on the grounds of cultural relativism, which is not exactly the same as religion, but it can be similar. So how do we reconcile the two? And I'll throw this question to all of our panelists.
Well, I could start. The policy paper makes it clear that there is no excuses that can be used to violate fundamental rights or to commit crimes that have been committed under the statute. And I think international law makes that clear as well. I think the issue of culture is interesting because when we look at crimes that are considered gender-based violence, they can look particularized, right? They don't look universal. So whether we're talking about honor crimes in Najaf or femicides in Mexico or the abuse of domestic violence workers in the US, we're talking about different forms of gender-based violence that look a little bit different. But when we're talking about gender persecution, they actually look the same everywhere. So it doesn't matter if it's, rape in Ukraine or if it's beating a woman in Mali for wearing a headscarf that was considered too transparent, or if it's torturing a young, man in Colombia for having long hair and an earring and not presenting masculinity the way the perpetrator prescribed to them. It doesn't matter. When we look at these crimes in all of these different instances, they have a universality to them. They're not culture. They look the same everywhere we go. It's about dress regulations. It's about roles. It's about attributes, behaviors. And it's about enforcing them. Often it's about enforcing them through crimes. Sometimes the crime itself, like forced marriage or enslavement, is the role that is assigned. So there's really a universality to these crimes, and that once we start looking and we start applying the elements of gender persecution to them, to the acts, we start to see that they amount to persecution in a criminal context.
I wanted to add something.
Go ahead.
I defer completely to Lisa on this question generally, but just again, listening to her reminds me, there is case law in refugee jurisprudence, at least, that also emphasizes for religion or political opinion, the freedom to not subscribe to a religion or political opinion, right? And so by not conforming to the dictates or the dress codes that might be the norm in a religious community or the activities of a political group, like neutrality itself, we have the right to not espouse a religious practice or a religious or political opinion, for example. So, and I can't claim to be an expert on the European Parliament position, but I do think that this excerpt, it's a very provocative excerpt, but I do think that it doesn't quite include all of the other fundamental rights one has to not practice, actually.
Madeline?
Yeah, because I just jump in on that because that's the European Parliament. And if you look at the European Court of Human Rights, what their jurisprudence has said, and also what comes from the human rights treaty bodies themselves, is that there's a margin of appreciation in relation to acts which are committed. So there's no way that you could do the sorts of things that would amount to persecution and say, well, that's cultural, it's all right. No, it's not a get out of jail free card for anything. And I was hoping, Lisa, you would talk about your golden handcuffs, because I really like that when you mentioned that when you've been teaching this before, about how you cannot, in terms of now we've gone to gender persecution as a criminal act, you get rid of that margin of appreciation. You do not get to do those things because they're prescribed by law.
Sure, I can comment on that. It's about Madeline's referring to the jurisdiction of the International Criminal Court. So it's not within the court's jurisdiction to go after gender persecution that's on its own. It has to be committed in connection to any act or crime under the statute. And that's a unique provision within the Rome Statute. It doesn't exist under customary international law in the definition of persecution, but it does limit where the court can look at gender persecution cases. So in that way, it's really looking at it in the context of crimes against humanity.
Thank you. Now we have some more specific questions that have come in about the court. So let me go through some of these. So first, and I think this is a fairly fundamental point, but I do think it's important to address. One of the questions is, how does the OTP's gender persecution policy intersect with the OTP's case selection and prioritization policy? As we all know, the court does not have unlimited resources. So is this now essentially a part of the prosecutor's discretion in selecting cases to bring charges of gender persecution?
I could just comment on that it does intersect with all of the policy papers under the court. And if you look at the gender persecution policy, you'll find many of the policies of the court footnoted or cited to and discussed in terms of their reference and intersection with the crime of gender persecution. So in terms of case selection and prioritization, the office, it is committed to paying particular attention to the commission of these crimes, including gender persecution, at all stages of its work, from preliminary examination, investigation, to trial, sentencing, appeal, reparations, and that is based on the policy on selection and prioritization of cases.
Thank you. Now we have a few more specific questions. One of which is specifically addressed to Pubudu, so I will go to you next then. And the question is it more common to find direct or indirect evidence of a special intent to discriminate? And I think that's if we wanted to rephrase this a little bit more broadly, we can talk about, again, the difficulty in actually finding the evidence that you need to prove the discriminatory intent.
Right. And again, this may well vary from whether are you talking about Mali, are you talking about Sudan, are you talking about the Ivory Coast, are you talking about a particular sub-region, a particular ethnic group in a particular sub-region? So there's no one-size-fits-all answer, but of course I think there is a danger in focusing too much on direct evidence, because I think we've had a conversation already about the word holistic and what it means in different contexts. And I think when you're building an investigation and building or developing an investigation and building a case, it's very important to think of all of these building blocks. You have the political context, statements made by high-level perpetrators, statements made by mid-level perpetrators, low-level perpetrators. But it may well be that those need to be interpreted in the context of what's happening on the ground. How is targeting happening on the ground? Who is being stopped at a particular checkpoint, and who is being separated and who is being treated differently after being stopped at a particular checkpoint? So I would say that direct and indirect evidence should be treated together, to view the situation as a sort of canvas. I think the best investigators and the best prosecutors think of a particular situation or a particular criminal episode as a canvas where you have there's a web of direct and indirect evidence being brought together to form an accurate picture. Sorry, that was a long and rambling way of saying there are both types of evidence available often, and they have to be considered together importantly.
Thank you. Now, another question that's a little bit more specific, but I also think is important, is as follows. Can you speak to establishing discriminatory intent in the command responsibility context? In terms of knowledge, would a commander held responsible for gender persecution of his or her subordinates need to have knowledge of the subordinate's discriminatory intent itself? And if so, what type of evidence would establish this knowledge?
Okay, well, I could answer this question briefly. It's a big question. But to break it down, yes, under Article 25 of the statute, individuals, including military commanders or even non-military superiors, may be held responsible for gender persecution that they commit, either as individuals or jointly through another person, or if they order it or solicit or induce it or aid, abet, or in any way contribute to the commission or even attempted commission of those crimes. So in the case of military commanders, they can also be held responsible under Article 28 of the statute on the basis of command or superior responsibility. In every case, I will say, because I think this is really what the question is probably getting to. In every case of charging persecution, you have to show specific intent. So there has to be a specific intent element met with whoever you're charging. Somebody in the chain of command has to have specific intent to be able to charge it. So you have to show that when you're proving it. But yes, it is possible in that context of command or superior responsibility.
Thank you, Lisa. We had another question that we partially addressed earlier, but I do think it's important and I want to come back to this. So let me ask this question. What would you say about a system that is established on systematic gender persecution, for instance, Afghanistan or Iran? Do you think it's still fair to call it gender persecution, or do we need a different legal framework that describes this phenomenon precisely and comprehensively? And I'm thinking perhaps of the human rights framework. So, Madeline, let me go to you on this question. Are those contexts, are we still talking about gender persecution? Or are we talking about gender persecution and something else, something beyond?
I think you're talking about massive and widespread violation of human rights in both contexts. And when you look at the patterns, exactly as has been described by the other panelists, that's when you arrive at gender persecution. So if you look at the nature of the harms that are being perpetrated in both states, they are highly, highly gendered. And as a result of that, within the context of human rights violations, you can then hone in on the nature of the crimes being perpetrated on the basis of gender, and that is intentional in order to perpetrate this division and maintain a very patriarchal control over the state. So I think, yes, there are massive, again, it sits within human rights, but then you can actually do the gender analysis, and then that brings us to where we are. And there is now, as you know, a huge push by women from both countries to elevate it, to actually name it as gender apartheid, for which there's no legal definition as yet, but they're seeing the very structural nature of that persecution as amounting to that, which I think is an interesting development in terms of thinking.
I would just piggyback off that question to say, yes, you can have entire wars that are, defined as persecution. We have them. We've had ethnic wars, religious wars. Those are persecution wars. We could have a war that's defined by gender persecution, and it would speak to those systemic or systematic violations that are happening. That's certainly possible. It's also true that we like cumulative charging. Right? We like cumulative charging because it helps us tell the holistic story of what's happening in conflict. So it's not a choice of, do we choose gender persecution or something else? It's about what is the right term that's talking about what's happening in conflict. And oftentimes that's more than one term. For example, rape is a form of torture. When you're charging rape and torture, or rape is an underlying act of torture, you're trying to highlight the egregious nature of torture and the egregious nature of rape that elevates it to this act of torture. That's what we do with cumulative charging. And persecution is a cumulative charge. It's often the charge that we're adding to a direct and underlying crime. It's naming that murder or that rape or that act of torture as an act of persecution as well. And then you can have other charges, just like genocide. And you could charge rape, torture, persecution, and genocide all within the same context. And that would be appropriate under cumulative charging. I also think that would just be appropriate, generally in terms of what we're trying to achieve and telling the holistic story of what happens in conflict. So with gender apartheid, if it were to get a legal definition and we would be able to use that as a tool, you would charge rape and torture and gender persecution and gender apartheid, and genocide in contexts where that made sense. You would be able to charge all of those different types of acts that are happening, and that would really tell the story of what's happening so that we understand, we get a holistic picture, so that conflict hopefully doesn't repeat itself. That's part of what we're trying to do, is not just go after individual responsibility. We're also trying to tell the story of what's happened to victims. And we do that best when we include every charge that accurately describes it, that we're allowed to under that process of cumulative charging.
Madeline?
I can just come back on that because I think that was beautifully put, Lisa, because if you go back to the situation in Iran, what accurately describes what's happening there is gender persecution, but it also surfaced everything that existed before. So now we're using this language, which actually then does accurately reflect the experiences. And I think that's so important. And it should, in all contexts, then inform what must happen in a period of transition and how we should be then looking back at the persecution to find ways in which you can redress that and find ways of moving into a non-discriminatory framework, which will make the fundamental changes that will obviously be needed.
Yeah, I mean, I would also add, if I can, last
Please
point.
go ahead.
I would just to piggyback off of that, it's the flip side to this coin is that we can only, as a court, as the International Criminal Court, go after those crimes where we have jurisdiction and where they've met the elements under the statute. So certainly gender persecution happens in lots of different contexts, some of the contexts which we've talked about on this call, but not all of those contexts are gender persecution as a crime against humanity under the Rome Statute. Some of them might be gender persecution as a human rights violation. But to reach that standard of a crime against humanity, we need to meet all 6 of those elements, including element 4, that connection to a crime or act under the statute. So that's the one place where we are limited in this idea of cumulative charging. We got to get the jurisdiction first, then we can do the cumulative charging.
Kim, did you want to jump in?
I'm just enjoying this back and forth so much, and I keep wanting to open my mouth, and then Madeline or Lisa say exactly what I wanted to say. So but I would say that one thing that struck me listening is, even though this is the golden handcuff situation that Lisa described, it's such a valuable potential charge, because what it does open up what Madeline is getting at, in that maybe in case of conviction, having persecution in there allows for a broader approach to reparations. If what this tells us is the truth about sort of historical systems of oppression that are flowing into the crimes that we're charging, then I think it allows us to think more systematically what's within the ambit or the power of the court to do in terms of reparations. And not all of it will be, I think, but it does open that space a little bit more for thinking about the reparative stage in case of conviction. And then the other thing, I have a little asterisk that I've been holding on to, and I'm sorry if it takes us too far back, but just in the question about command responsibility after I listened to Lisa, the other thing that occurs to me is, of course, command and spirit of responsibility, they're forms of omission liability, right? So it may also be that that we're looking at failure to prevent or punish because of reasons of gender discrimination also, right? I mean, I think that even if a commander may not share all of the identical intent of everyone on the ladder below him necessarily. It might be, right, quite clear that failure to punish or prevent an act is also fueled by the same discriminatory animus. So that was just a thought I was having about mission liabilities in general.
Thank you. I think we have time for perhaps one more audience question, and this is an important one as well. So let me read the question and let me perhaps reframe it just a little bit. Apologies to the audience member who asked this question, but it goes as follows. In the US context, for example, does the term hate crime fully encompass the systemic nature of gender-based violence? As individual instances of violence against women are inherently connected, do you feel that there are accurate domestic legal tools to fully recognize the systemic nature of these crimes? So how I would rephrase this is to talk about the ICC's positive complementarity mission. And I know that, Lisa, for example, you have worked in Colombia and perhaps in other places. So can you perhaps tell us just a little bit about, you know, on the one hand, there's the ICC policy itself, but then there's also this role of the ICC as essentially working with domestic legal authorities and trying to develop some of the same understandings, if you will, of the crime that you're trying to address at the ICC. So in 2 minutes, if you can tell us a little bit about Colombia or perhaps any other jurisdiction that you have worked with.
Sure. Well, as everyone may know, the court just signed an agreement with the HEP in Colombia to provide technical assistance. I think that agreement was signed in June or July, and we've already taken a trip down there in August to provide that assistance to judges in the special jurisdiction for peace. And the big issue we were talking about was gender persecution and making sure that our understanding and their understanding are in sync and that they have the right tools and resources that they need to be able to understand it within Colombia's context. So it was a very successful trip. I know it was very important to the prosecutor, who is also committed to opening offices in different conflict contexts where the court works, so that we have that in-country presence to be able to work with domestic leadership and with civil society. So there's a lot of great changes that are happening in the office, and really working towards this idea of building collaboration, trust, and understanding on these charges.
Thank you, Lisa, and thank you so much for sticking to our time frame today, because unfortunately we are running out of time. So thank you to all of our panelists for joining us today, and thank you to all of our audience members for joining us and for submitting all of these questions. We were able to have such an interesting conversation based on all of your questions. The webinar recording will be available on the PILPG website, and it will also be shared with all of our attendees via email. This event was part of the PILPG Thought Leadership Initiative. This event was the fourth in a series of events that we're holding on this topic of the policy on gender persecution. Once again, I'm deeply grateful to our panelists for taking the time today to talk about the ICC policy on gender persecution, as well as to our audience for their participation. And I invite all of you to join us on October 26th for the next event of this series on the connection of gender persecution with any other crimes under the statute. Thank you so much for joining us today.